Hello again, everyone. It is Rob Ryder on April 10th, 2016. Wow, this month is a third over. Sticking them with the bill. Compelling an attorney appearing on behalf of the United States to submit a bill of information to a special grand jury in accordance with Title 18, United States Code 3332, USC 3332. You'd think it'd be quite easy to do, but as with everything, they just don't seem to like to do it. And then things to do when they refuse. So I don't know if these will work. They're just things that I've done based on responses I've gotten, and I think it's kind of interesting. Because your issue, whether it's a foreclosure or a traffic ticket or taxes or whatever, is a symptom of the problem. And the only cure for a symptom is eradication of the problem. So we need to determine what the problem is, and all of these symptoms have one core problem: that they don't follow the law. It's that simple. The supreme law of the land is the laws of the United States, but try to get anybody to enforce the laws of the United States. They don't want to do it. They'll say it's a state issue. You say, yeah, well, it could be a state issue. Sure, there it is in the penal code, but here it is in the federal law, and I just as soon use the federal law. Because why? Well, because it's the supreme law of the land. And every officer of the United States has a duty to enforce the laws of the United States. Now, they may not be law enforcement, but if you bring it to them, they need to get it to those who enforce the laws of the United States. Or it's an act of treason. And, we'll let a jury or their peers decide. And so this is all kind of predicated on, I was doing a video here last week, and not that one. I got done. I went and checked the mail, and this was out in the mail. It was a letter from Clarence Maddox, who is the circuit executive for the United States Courts of Appeals for the 6th Circuit in Cincinnati, Ohio. Dated April 4, 2016, to Robert Allen Ritlewski. Hey, they put my name in proper case. Thank you very much. 10955, 14 Mile Road, Northeast, Oakfield, Michigan, 49341. Now, it isn't the first time I've had my name sent back to me in proper case. They will do that. But normally, unless you compel them to do it, they're going to want to send it to your all caps or to your middle initial name or to Robert A. Ritlewski, or to your name backwards, like Ritlewski, Robert Allen. All right, they don't like to address you and your proper person, because that would mean, well, we got to admit you're here. And so it was Ari in regards to a complaint of judicial misconduct, number 6-16-90024. Dear Mr. Ritlewski, this will acknowledge receipt of your complaint of judicial misconduct against United States Magistrate Judge Ray Kent. Your complaint has been filed and assigned the above complaint number. Please place this number on all future correspondence. In accordance with Rule 8B of the Rules of Judicial Conduct and Judicial Disability Proceedings and Rule 3A2 of the Rules Governing Complaints of Judicial Misconduct or Disability, a copy of the complaint will be sent to Chief Judge R. Guy Cole, Jr. I will advise you further upon the disposition of this matter. Sincerely, Clarence Maddox, Circuit Executive. So hey, that's not a letter most people get daily. I hadn't got one in quite some time I never got one quite like this. Period. Just quickly, I got to look at come on. Look at the envelope, because the envelopes have lots of information on them, especially when you compare them to other envelopes. See here, like they sent it to my 5-digit zip code, 49341, but down here on the barcode, it's got my 11-digit zip code. 49341-8664 is the zip code +4, most people know, and then the 55 are part of the last 3 digits that go on the end, that actually that number right there specifies, right down to your mailbox, basically, where it sits in the ground. And it was official business, outstanding. Now, having looked at lots of envelopes before, what I didn't like, and you really can't see it on here, is this didn't say it was first-class mail. Although it has been canceled, it hasn't been postmarked, because a postmark is a round, black dot, circle. This didn't have a round circle on it. But it did have these wavy bars, which can cancel a stamp, but it isn't the same as being postmarked. It does cancel the stamp, yes, but it's not postmarked, because a postmark is a black round seal that's got certain information in it about the post office that canceled it. And so we don't have to look at it again. You can see they used their +4 as the zip code, and they sent it to my 5-digit zip code, so it's like, well, that's really 2 different jurisdictions. There are those that will tell you that, the +4, as you see it here, would be entities existing in the District of Columbia, right? That's where they're from, as opposed to a 5-digit zip code that says, well, that's where you're from, right? So mine says I'm from this jurisdiction here, or that's what I claimed when I said to them, that I'm from the 49341 district that is part of the elemental district that I inhabit. Okay, but enough on, it's a whole study on its own, but enough on that. Let's go back to where we were. Okay, so because I got that, I said, well, I'm going to go back, let me do a video on this. We'll just start from the beginning, and which we're going to do. But if you can, please donate. The PayPal account is ashleyrytlewski@gmail.com, ASHLEYRYTLEWSKI @gmail.com. Or there's always the regular mail, Robert Rytlewski. Yeah, Rob Ryder's not my real name. 10955 14 Mile Road Northeast, Rockford, Michigan 49341. But neither is Robert A. Rytlewski, and they send me mail that way. That's your, like your federal name with the middle initial. They didn't get your full name. Your proper name, my proper name, nobody's proper name, Robert Allen Rytlewski, properly done, has not been registered in the right books of the United States of America, which is the Confederacy of the Free and Independent States, established under the Articles of Confederation and Perpetual Union. It shall be known by the style of the United States of America, with the being part of the proper noun name, not lowercase. So United States of America is not the same as the United States of America. One is the Republic of the Free and Independent States, and the other one is part of the territory of King George III and his successors. Okay, well, let's continue on. Enough of that. So what I did, this all started back on August 12th of this summer. And a lot didn't happen because I didn't do anything until I thought about it later, trying something else. But it started with this. So I found the email address to the uscourts.gov in Western Michigan. I said, hey, I'm going to send me an email with a complaint attached to it to this address and tell them to give it to the grand jury. I consider them to be an attorney of the United States. Right, so I, Robert Allen Rytlewski, representing the people of the United States, wish the grand jury investigate the infamous crimes of Planned Parenthood Federation of America Incorporated, listed on the attached Bill of Information. An attorney refusing to submit this bill to the grand jury is in violation of laws of the United States. Actually, they're in violation of, we can get even more specific, let's say Article 6 of the Constitution, one of my constitutional protections. In accordance with local court rules, please inform the Chief Judge of their refusal to follow the law. So 18 U.S.C. 3332, powers and duties, since this is a law of the United States, and anybody who's taken an oath to support the Constitution has to enforce the laws of the United States, even if it's just your local justice of the peace. Well, this is what it says. It shall be the duty of each such grand jury and panel within any judicial district to inquire into offenses against the criminal laws of the United States alleged to have been committed within that district. Laws of the United States, criminal laws, that would be like Title 18 stuff. Such alleged offenses may be brought to the attention of the grand jury, by court, or by any attorney appearing on behalf of the United States for presentation of evidence. All right, so it didn't say the United States attorney, it said any attorney, lowercase attorney. Go look at what the definition of attorney is. Not as somebody's part of their title, but just what it is to be an attorney. It means to represent somebody, and I can be an attorney. You just need to give me power of attorney, and I'm your attorney. And really, that's all you ever do with a person that you think is an attorney at law is you ever hire one, you're going to sign a piece of paper and give them, guess what? Power of attorney. So they're going to represent you, but they're not going to give you any legal advice. That's what this guy is. I'm not looking for his legal advice. I want him to represent me or the United States. In this case, he's representing the United States for the presentation of evidence. Well, that should be any officer of the United States. They represent the United States. So if I give a complaint to an officer of the United States, he has a duty to get it to the right office. It's not my job, it's his. My duty was finding him. His duty is getting it executed. So anyways, any such attorney receiving information concerning such alleged offense from any other person shall, if requested by such person, hey, that would be me, inform the grand jury of such alleged offenses, the identity of such person, and such attorney's action or recommendation. Well, that just seems just as simple as it can be. Well, I'll just email it to the jury. The jury clerk's going to get it, and they're an officer of the United States because they're working for the United States. Well, they're an attorney. They're representing the United States. I won't even say they're an officer, but they are an employee, and they work for an officer, and therefore, hey, it's one big happy family. You had a duty. So that was that part. Now, what did this thing look like? All right, so what I sent them. So I did that on the 12th, and it wasn't until some time ago, because I really didn't know what they did with this until I got an answer back that included a copy of it. But as you can see, so it was the 12th I sent it by email. Well, it was received on the 20th by the U.S. District Court, Western District of Michigan, right? Clerk, Tracy Cordes, Clerk, U.S. District Court, Western District of Michigan. Bill of Information, submitted to grand jury. I, Robert Allen Rutluski, one of the people in the United States, see Exhibit A, representing the same, by this information, inform the court of infamous crimes committed against the laws of the United States. And I've done enough videos on, my love of this Planned Parenthood Federation of America to show that I've submitted many complaints in as many different ways as I can to point out these very simple federal laws that it's really all it takes to say, hey, they're violating, or they're evading taxes. And it isn't just Planned Parenthood, it's any 501c3 that is contributing to campaign financing, because it's just against the law. It's real simple. Watch my last video and I really went into that in a lot more detail. So, but because of who they are, they can't contribute, and that would be a violation of Title II U.S. Code 441B. And because they're not who they say they are, and they're still submitting, so they're acting like they're nonprofits, but they violated this code because they've contributed, so they're really not a nonprofit. They're just evading taxes, acting as a nonprofit. Well, they've committed a crime. Well, then anything else they submit that says that they're still a nonprofit, well, that would be a false statement, and that would be covered under 18 U.S.C. 1001. False statements. Omission of material facts are false statements, and false statements are false statements. Well, they're still calling themselves a 501c3, even though they're violated to U.S. Code 441B. And it wasn't just me that said it. The Federal Election Commission said they violated it. Okay. Planned Planned Parenthood, Federation, their address, directly or indirectly engages in campaign contributions in violation of, extinguishing their presumed tax-exempt status as that of a public charity, rendering their IRS Form 990 as a false statement used in an attempt to evade taxes. That's as much as it took. One paragraph to give probable cause of these son of a bitches are, in violation of the laws of the United States. So where is the officer of the United States that's going to enforce these laws? I'd really like to know. I'll keep looking. Planned Parenthood Federation of America directly controls Planned Parenthood Action Fund and other indirectly as noted in Schedule R attached to Form 990. So I'd send them a few exhibits, blah, 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 yep, and then these people have a committee ID number with the Federal Election Commission. So, they're not even supposed to be involved in it. Hell, they got a committee ID number, for God's sakes. And so this was my evidence, right? Here's my baptismal certificate. And really, it's the only document, the only official document that I can find that has my proper name on it. But, and this is for anybody that is baptized, go look at yours. And just like on your birth documents, your mother is going to be in her maiden name. Well, that means they weren't married. So even though my parents were married in a Catholic church, and I'm being baptized in a Catholic church, by the record, my mom and dad were never married. So they're just baptizing a bastard pagan. Well, at least a bastard. And, in Jewish law, a bastard can't inherit. And so if the Jews control the world under the Noahide laws, then they wouldn't let me inherit my inheritance from God the Father. So that was that. And then here's the 990. So you could go find a 990 for pretty much any 501c3 that's big enough to have a website. They're going to proudly put this shit on there someplace, their financials. And you'll see that Planned Parenthood Federation of America, right, not doing business as anybody, so that's their name, with this address, with Cecil Richards, their principal officer, attesting to the fact that they are a 501c3. Wow. That would be a false statement in violation 18 U.S.C., United States Code 1001. Busted. And this is just a page that's the Schedule R, which is part of a 990. And this lists all the other entities that they may have something to do with. And, well, here you are, right? There's, what do we do? Oh, there's the Action Fund. There's Planned Parenthood Foundation. There's Planned Parenthood Votes. Oh, that sounds like it has something to do with elections. Planned Parenthood Action Fund Incorporated Pact. Oh, well, that sounds like the Planned Parenthood Action Fund with another word added to it to make it a different entity. 501c4, 501c3, 527, 527. Right? So can these people be involved in contributions? I don't really know. But I know a 501c3 can't, and all of these are entities that the 501c3 has control over. They share the boards. All right. So I had sent that, and sent it on the 12th. She got it on the 20th, and then on the 21st of August, it ends up at the United States District Court, Western District of Michigan, Southern Division. N.R.E. Robert Allen Rytlewski. Well, before we go any further, they just opened a court case using my name. Because N.R.E. is the proper way to do a, like a probate. Petitions and so forth, right? And it's like, wow, they, I don't know what jurisdiction it is, but they're acting like opening a court case. They didn't give it a court case number. It's just N.R.E. and it's me. Well, anyways, and it had to be because it's an order rejecting a pleading. So they had to open a court case to issue an order. And so the court has examined the following documents received August 20, 2015 and orders the clerk to reject the criminal complaint and return the documents to Robert Allen Rytlewski for reasons noted below. Robert Allen Rytlewski is attempting to file a criminal complaint A criminal complaint may be initiated only by the United States Attorney's Office and not by an individual. It is so ordered. August 21st, 2015, by Ray Kent. Ray Kent, U.S. Magistrate Judge. Well, that was at that time, that was really interesting because, hey, it came in an envelope too. And in that envelope, which is a lot like the one I got, just different, because this one says it's first class mail, but it doesn't have any squigglies through it, so it was never canceled. But it went to my 11-digit zip code, and the way they're addressing these are the ways I addressed whatever it is I sent to them. So the fact that this says Oakfield Township and the other one doesn't is because I just put Oakfield on the other one. But again, they sent it to my proper case name at the address I gave them. But they didn't cancel the frickin' postage, and there's no round black post date. Now again, postmarks need to be black. Black, 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 black. Round, black, postmark. It's in the fucking domestic mail manual, for God's sakes. Excuse my French. So let's move on. So this dude named Ray Kent, saying that he's a frickin' attorney, or that he's a U.S. magistrate judge, is denying submitting my bill of complaint to the grand jury after admitting that I'm trying to file a criminal complaint, and he's saying the only one that can do it is the United States Attorney's Office. Well, raise your hand if you believe that to be correct. All right, then walk over and stand in the corner for a while, because you got some extra duty, man. You need to get this stuff figured out in your head. They aren't. They're not who they say they are. All right? Anybody can initiate a criminal complaint. So the way, the United States the United States of America can initiate a criminal complaint by you being its relator, ex-rel relator. All right, so there we are. So I had, that was interesting. And then where do we go from there? So then I sat on it for a bit because I didn't really know what I was going to do, and it wasn't because we're like the 22nd now of August. So on September 4th, I finally got around to doing something, and I said I'm going to write Tracy Cordes, the clerk of the court, for the court that I had sent the document to, who had should probably just leave these things open as I do them. All right. Who had said that she received it. Tracy Cordes, clerk. Clerk of the court, Cordes. I have attached a copy of a simulated legal process. Order rejecting pleading. That would be this. I say that this is a simulated legal process. Right? Using color of law, and therefore, it's a civil rights violation, a violation of the Constitution. We could just go through all the things it's a violation of, but at the end of the day, it's an international war crime. I have attached a copy of a simulated legal process that was sent using the mails, within which an individual calling himself Ray Kent is claiming to have some non-existent authority in common law criminal matter. Ray Kent is an assumed name of a licensed attorney, Raymond S. Kent, most recently associated with the Federal Public Defender's Western District of Michigan offices. Well, how do you find that out? You go look their name up on the State Bar website. The United States District Court, Western District of Michigan, is not an Article III court and has no jurisdiction in criminal matter. However, in his Office of Attorney and Counselor at Law, Attorney Raymond S. Kent, P44156, has a duty as a public officer to forward my complaint to the grand jury. To not do so would be a violation of 18 U.S. Code 3332. It shall be the duty of each. Well, I've already read that to you, right? Any such attorney receiving information concerning such alleged offense from any other person shall, if requested by such other person, inform the grand jury of such alleged offenses. And that's what I wanted him to do. I wanted somebody to do. And they sent it back, said, hey, you can't do this. I wish you, clerk of the court, courts inform Attorney Raymond S. Kent to inform the grand jury of the alleged offenses already on file with the court regarding the unlawful activity of Planned Parenthood Federation of America. Ray may have violated any number of laws, and I leave it to the court's judgment on how to best serve justice in this matter. The clerk of the court is also a public officer with duties under common law, like enforcing the laws of the United States and prosecuting breaches of the peace, such as trespass, on the case. Should Attorney Raymond S. Kent be unable or unwilling to execute his fiduciary duties and deliver said information to the grand jury for their investigation into the facts, then I order the clerk of the court to execute the law and have Attorney Raymond S. Kent arrested, and for the clerk of the court deliver the information to the grand jury on behalf of the court. Simple enough. He won't do it, we'll have him arrested and you do it. But right now, he's the one with the hot potato. Ray Kent, a.k.a. Raymond J. Kent. S. Kent? J. Kent? I don't know. S. Kent, I guess. And there you go. So I sent that, and that was really, didn't hear anything, didn't happen until I got the letter that I just showed you. Well, I take that back. That isn't quite what happened. So I got that far. So now we're in September. And because of the things I'm looking at now, it came to me that looking at the different courts and stuff, and I said, hey, that's right, because I had tried to do this before. I said, I can send a judicial complaint to the Circuit Executive of the U.S. Court of Appeals for the Sixth Circuit, that's the circuit that I'm in, for a judicial complaint. And, so if you go to your appeals for whatever circuit, you'll find, probably under the Circuit Executive, like this, for judicial complaints, where you can pull off a form to fill out and send it in and make a complaint. And so, now we can think of all different kinds of complaints it could be, but the simplest one is the guy who's saying that he's a judge isn't using his proper name. And he's not enforcing the laws of the United States. Well, that would put him in violation of Article 6 of the Constitution. It says the supreme law of the land is the Constitution and the laws established thereunder, blah, 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 blah. Okay, well, if they're not doing that, then that's a violation of Article 6. Right? Now, these aren't the amendments. These are the articles. The meat and potatoes of the Constitution are the articles. And they don't give you any rights. They just give you protections. Your rights were made unalienable under the Declaration of Independence. The Constitution is established as a shield to protect your rights, with officers with powers to do so, subordinate to you, who are supposed to be protecting your rights. And they just didn't do that. They're facing the wrong direction. They think you're the problem. And so we need to, correct their behavior and go the other way. So judicial complaints, right? Judicial complaint form, rules, everything you could possibly want to know, you can find. Okay. I'll close some of these up. Don't need that one. We don't need that one. 4. Okay. So what happened next? So I went to that form. And this is kind of what it looks like. It's one of those kind that it's got the purplish border on it, so you can't edit the form, but you can fill it in. And so you would put what district, because apparently this can be used for all of them, so I'm assuming this is the same form for everybody. And there's a certain way you can do it. And so you put in the complainant and so forth and so on, and who it is, and the backside, two-sided form if there's anybody involved. So this is kind of what I did. I started with, right? So I said, okay, name a complainant. Well, the complainant is the United States, right? Its laws have been broken. I'm just the relator. But the contact address, that would be my address. And the name of the judge, well, that's this dude named Ray Kent in the court. Apparently, it's United States District Court. That's what it said on the paper. Does this complaint concern the behavior of a judge or participant lawsuit? Yes. And the lawsuit was the fact that they gave me that this right here, right? This, to me, is the opening of a lawsuit. It's an order rejecting pleading in Robert Allen Rutluski in that court case. And that's why I said, well, then I'm going to say that Tracy Cords is my attorney, although it said lawyer, so I don't know if I'll get away with that, but that doesn't matter to me. I don't know if she's a lawyer or not. If it said attorney, I'd say, yeah, you are. You're representing the United States. I just made you my attorney. I don't know if clerks are attorneys or not. But she's my lawyer. She didn't say she wasn't, so I assume she is. No other lawsuits were filed, and then you've got to give a brief statement of facts that you're going to write on something else, and then you're going to sign it. I declare under penalty of perjury the statements made in this complaint are true and correct to the best of my knowledge. Yeah, I can live with that. Absolutely. So that's what I did. And not only did I do that, so I changed it up just a little bit. So I said, well, I'm going to make it the United States of America, XREL, and I'll just write my name in. Because there wasn't enough space for me to write my name in. If you didn't have as long a name as mine, you could probably put it in there. And I said, well, it's Raymond S. Kent, a.k.a. Ray Kent, because Raymond S. Kent is the guy that if anybody was the judge, it would have to be him because he's the attorney. There is no attorney named Ray Kent, so he can't be a district court judge or a U.S. magistrate. Yes, so what was it? The United States of America, NRE, Robert Allen Rutluski. That seems good enough. And I'm a party. And so that was, that's the way this did. And I added it up here. I put, I'm going to put in here, in the name of the United States of America, I waive all customary rules and other procedural impediments. Because if they have a certain procedure that needs to be followed and you don't know all the steps and you miss a step, well, they don't need to look at your paper because, hey, you didn't follow the procedure. Well, they could do that just to make it really hard. They could do that as a way to obstruct justice, right? So I just say I waive them all. Well, that's fine. You can have them, but I waive them. I don't want those. I'm speaking for the United States of America, and I don't want any customary rules or other procedural impediments. I want a remedy. But then the coolest thing is I put a stamp on it. I put a dollar stamp and I crossed it out. Right, so I canceled the stamp. Did this form, and then I did the facts for the circuit court. And I put for the brief of facts, I said, officers and employees of the U.S. Court of Appeals for the Sixth Circuit, in the name of the Lord Almighty, I accept your oaths, bind you to the same, and demand you do justice. I waive all customary rules of law and other procedural impediments. I, Robert Allen Rutluski, relator for the United States of America, inform all officers of the United States of the obstruction of justice and the use of a simulated legal process by color of law sent using first-class mail, that envelope does say that, from Office of the Clerk, United States District Court, to Robert Allen Rutluski. On August 20th, 2015, at 10:20 a.m., Tracy Cords, Clerk, U.S. District Court, Western District of Michigan, acknowledged receipt of a bill of information I was attempting to submit to the grand jury, U.S. District Court, 110 West Michigan, 399 Federal Building, Grand Rapids, Michigan. The bill of information provided probable cause that Planned Parenthood Federation of America Incorporated, et al., directly or indirectly engages in campaign finance, campaign contributions. The same being a violation of 2 U.S. Code 441B. This violation extinguishes any presumed tax-exempt status, rendering this entity's various corporations liable for back taxes to the first instance of said violation. That'd be like ipso facto. Currently, Planned Parenthood Federation of America, Inc., et al. Is a tax-evading participant in an antitrust scheme. Yes, that's what they are. Instead of my bill being forwarded to the grand jury, it was returned to me with an order rejecting pleading. NRE, Robert Allen Rutluski. So ordered by one Ray Kent, a U.S. Magistrate Judge, representing United States District Court, Western District of Michigan, Southern Division, dated August 21st, 2015. Take judicial notice. I do not believe this is the proper name of an Article 3 court, as this order is not under court seal. Simple enough. I don't see any frickin' seal on the damn paper. You're going to say it's an order, brother. You better have the damn seal of the United States on it. Ray Kent is a fictitious name not found on the State Bar of Michigan members directory. There is, however, a Raymond S. Kent with P44156 claiming to be an attorney at law and U.S. Magistrate Judge, Western District of Michigan. I believe Raymond S. Kent is also an unregistered assumed name not to be found on said roll of attorneys. So again, someplace in your state at the Supreme Court or whatever, the Supreme Court, somewhere, is a thing called the roll of attorneys that all attorneys who are attorneys properly are supposed to be enrolled on. If they're not on that, they're not an attorney and they can't practice law within the state of Michigan or whatever it is. So, prove to me that you're an attorney. Show me. I want to see a certificate that says your name's in the official roll of attorneys. By whatever pseudonym this man uses, he has simulated a legal process by color of law, violated the laws of the United States and international law, dishonored his office of trust, and aided human traffickers in profiting from the sale of God's unborn creation. I replied on September 4, 2016 to Clerk Cords that it was a violation of 18 U.S. Code 3332 for an officer of the United States not to submit my bill to a special grand jury. Yet the harvesting of God's creation for profit continues. Both individuals, a.k.a. Tracy Cord and Ray Kent, have a duty as officers of the United States to see that the laws of the United States are executed and enforced. Unfortunately, both these individuals have instead obstructed justice, engaged in an unlawful combination, and numerous other crimes against the United States of America. Lord Almighty demands the bill of information be filed with grand jury and these unruly federal officers be reprimanded. Robert Allen Rutluski, Office of Christ. Nobody's yet to rebut the presumption, so I'm claiming the office. And I had some exhibits. I sent him an alleged order rejecting the pleading, which we already read, the envelope that went to it, the bill we looked at, and the reply to Clerk Courts. Things we already looked at. Put them all in an envelope. And this is what it says on the State Bar of Michigan website. Raymond S. Kent. Well, that isn't Ray Kent. So, jeepers, pretty easy so far, right? This isn't rocket science. Just go to your state's bar, because there's many bars within your state, but the one that they have to be members of. Just go see what they have to do to be a member of the bar to be able to practice in the state, right? And I was looking at something the other day, and just the other day, it had to do with judicial elections in Illinois. And these judges are supposed to be judges of the resident circuit court judge, some county, Illinois, some county. So, resident circuit court judge, Kane County. That's their title, but that isn't what they run for. When you look online and you look at the election, they're running for judge of the judicial circuit. And that judicial has nothing, that's not the word that should be in the name of the thing. I forget where I was going with that. It had something to do with their name. Okay, I'll get back to what I had meant to talk about. Where are we now? Okay. Well, so I sent that in, and as you can see, I'm not going to not trying to make a big deal about it, but hey, I did send it with a stamp on it that I had canceled, and they wrote me back and said that, hey, I have a complaint now. Now, the thing with this complaint is you're supposed to write on the envelope, as you can see, enclose each copy of the complaint in an envelope marked complaint of misconduct or complaint of disability. I said it was a disability. not a misconduct, right? Because I'm saying that Ray Kent was never an attorney. Or excuse me, well, he's never an attorney, and he certainly was never a judge. So it's not judicial misconduct. He's not a judge. No, I'm not. He cannot have the title of a judge. That would be a violation of Article 6 protections. He has a disability because his appointment was unconstitutional, as I spoke about in the last video. So we had the facts, and I sent that along, and I got the answer I got, which was, I think that's what we're looking at here. Yep, so then that got me this in reply, to which I replied to today, and that's why I'm doing the video, right? So I can make a public record of my reply to this response to my complaint, which said complaint of judicial misconduct. Well, I don't believe it's judicial misconduct. I believe it to be judicial disability. But thank you anyways for the complaint and give me a tracking number. Outstanding. And that some dude, yep, you acknowledge and receive your complaint of a judicial misconduct against the United States Judge Ray Kent. Magistrate Judge. No. Disability of an assumed actor claiming to be a United States magistrate judge under an assumed name, a.k.a. Ray Kent. Your complaint has been filed and assigned the above complaint number. Please place this number on any future correspondence. I will be sure to. And according to some arbitrary rules of law, you've sent it to some dude called the Chief Judge R. Guy Cole Jr. Hey, he's using an initial too. I wonder if he's involved. He may be just as guilty as Ray was. Now, Clarence, he's not using no initials. Good for you, Clarence. But I'm not really sure you have a proper appointment, so we're going to have you checked out. We're going to send you all to the doctor. Have a proctology exam. So this was my response to Clarence. The United States of America, because they are the ones that are responding. I'm just speaking for them. The sovereign power. XREL, Robert Allen Mertlewski, Office of Christ. Circuit Executive Clarence Maddox, United States Court of Appeals for the Sixth Circuit. RE, order regarding 0616-90024, complaint of judicial disability. So I'm giving them an order regarding the complaint for judicial disability, not this misconduct. So, Circuit Executive Clarence Maddox, I am in receipt of your testimony. God, I love telling them that. Anytime they write you, when you write them back, say thank you for your testimony. I am in receipt of your testimony, dated April 4th, 2016, regarding the United States of America, complaint 0616-90024, copy included. Your mischaracterization of this matter compels me to respond in the following manner. Never refer to me as Mr. ever again. I have no respect of person, thus Robert Allen will suffice among us as equals before God. If titles must be used, then Sir, Elector, Lord, Christ are acceptable. By what title is necessary to pass your lips and enter your ear, activating your conscience voluntary submission to my superior sovereign status over your inferior office? Hey, that's fine by me. The United States complaint regarding Ray Kent is one of judicial disability, not judicial misconduct. In this instance, Ray Kent is at best a nickname. The individual using Ray Kent wasn't, isn't, never will be an officer of the United States in that name. Characterization of him as someone sharing in the sovereign powers of the United States of America is a violation of the Constitution of the United States, Article 6 protections. Well, of course it is. He's not who he says he is. I am just as concerned that you, Circuit Executive Clarence Maddox, may also be unconstitutionally appointed. Please send me a facsimile of your certificate of appointment under the Great Seal of the United States to validate your office, and then forward my bill of information that a.k.a. Ray Kent previously denied to the grand jury. Excellent. If you're an officer of the United States, then you do it. Clarence, potatoes in your lap. If you cannot prove a constitutionally valid appointment, then stop now before you irreparably harm yourself. Contact Circuit Justice Kagan and as witness inform her of the newly evidenced ongoing rebellion and insurrection by unconstitutionally appointed officers of the United States. Inform her she is to immediately contact the President of the United States in accordance with Section 2 of Militia Act of 1792 and end the rebellion. Until she can certify your appointment is constitutional, you are to limit your activities to those that will quicken the capture of these rebels and the confiscation of their property. Yeah, why not? Right, hey, you find out you're not constitutionally appointed, brother, you had better make a phone call and say you don't want to be part of the insurrection or rebellion, and you're pointing it out to the or to the justice of the circuit, who has a duty to make a phone call to the President of the United States and tell him that in accordance with Section 2 of the Militia Act 1792, he needs to issue a proclamation and quash the rebellion. Well, it's not just in Section 2, but that's where she gets involved. Complaint 0616-90024 is intended for a court convened under Article 3 of the Constitution. The federal subject matter of my complaint may require you to transfer said complaint to the United States Court of Appeals for the Federal Circuit, which claims to be an Article 3 court, and it sure does. If you didn't know, I will show you. United States Court of Appeals for the Federal Circuit, in which it says court jurisdiction. The United States Court of Appeals for the Federal Circuit was established under Article 3 of the Constitution. Period. I don't need to read anymore. I didn't see that on the Sixth Circuit, but I certainly saw it here. Okay. Which one of these frickin' things am I reading? That's Clarence. Okay. Okay, so complaint 0616-90024 is intended for a court convened under Article 3 of the Constitution. The federal subject matter of my complaint may require you to transfer said complaint to the United States Court of Appeals for the Federal Circuit, which claims to be an Article 3 court. I'm not doing anything. I'm giving orders. You do it. The testimony you provided seems to be a simulated legal process or some process of a private tribunal, perhaps ecclesiastic or foreign, with no federal powers. The paper it is written on does not have the official watermark of the federal government. It has no court seal, and it was not mailed domestic first class. Clarence, why is there no eagle watermark on your document? Did you know that the federal government has a watermark on their official paper? It's a big-ass seal of an eagle. And I don't have it on there. So it's not an official document of the United States of America. Well, then it must be a simulated document of the United States of America. Why does not your office use an official seal? And in an official matter involving the United States of America, and why would you use non-domestic mail in a matter of official business of the United States of America? That's what I wanted to know. Oh, where was that complaint at? Oh, here we go. All right, so, here's where you sign, but there's no seal on it, and this is just typing paper. It's not on any kind of cotton bond, and again, it's legal paper. Talked about it before. Now, my brother-in-law, Brian, who wrote his, both his congressman and his senator down in Florida, so he's U.S. congressman, U.S. senator, quasi, they claim they are. When he got his answers back from them, it was on legal paper that has an eagle on it that said 2014 on it. That's what the watermark is for, so that they can, it's a security device. You just can't be slipping pieces of paper into a document, without paper that's the same watermark as what was used for the rest of it. Okay, so the testimony you provided me, that's why I said it seems to be a simulated legal process or some process of a private tribunal, perhaps ecclesiastic or foreign with no federal powers. The paper it is written on does not have an official watermark of the federal government. It has no court seal, and it was not mailed domestic first class clearance. Why is there no watermark on your document? Why does not your office use an official seal in an official matter involving the United States of America? Why would you use non-domestic mail in a matter of official business of the United States of America? Clarence, further, any judge using an alias, that would be R. Guy Cole Jr., in place of his true name in an official capacity is presumably in violation of Article 6 protections of my unalienable rights. Was R. Guy Cole Jr. validly appointed to an office of the United States? Was his appointment in accordance with Article 2, Section 2, Clause 2 of the Constitution of the United States? Is he in receipt of a certificate of appointment under the Great Seal of the United States? The rule of law demands procedure be followed. This was made clear as crystal by the justices of the Supreme Court of the United States in Buckley v. Vallejo. We think that term, Office of the United States, as used in Article 2, defined to include all persons who can be said to hold an office under the government. That'd be the judicial branch, executive branch, and legislative branch, is a term intended to have substantive meaning. We think it's fair. Import is that any appointee exercising significant authority pursuant to the laws of the United States is an officer of the United States and must therefore be appointed in a manner prescribed by Section 2, Clause 2 of the article. If R. Guy Cole Jr.'s office required the participation of any member of the legislature for his appointment to be considered constitutional, we must then assume that his appointment is unconstitutional and he is to be relieved of all duties. He is further denied access to the building until proved that the Senate is properly seated and his appointment executed in accordance with the appointment clause, or until he is arrested and a trial for treason, or until his arrest and a trial for treason. Yeah, hey man, either you're going to become a bona fide sitting judge, or you're going to have your ass arrested and stand for treason. The omission of material facts and official records provides overwhelming probable cause for the President of the United States of America, which I did on purpose because there is a difference between the President of the United States and the President of the United States of America, even though it could be the same guy just wearing two hats, to issue a proclamation naming Confederate States of America participating in the rebellion against the United States, and to initiate the immediate confiscation of rebellious people's property. That would be under the Second Confiscation Act. An investigation will provide strong countervailing testimony to the claim that the people of the state are represented in Congress in accordance with Article 1, Sections 1, 2, 3 of the Constitution of the United States, thus paving the way to set free all persons, natural or legal, now held as slaves of any state, as designated part of the state. That's the Emancipation Proclamation, 1863, January 1st. I recently ordered the United States Coast Guard to investigate the election of each and every alleged senator or U.S. representative to ensure they complied with state and federal election laws and Title II of the United States Code. Please contact the Coast Guard and provide them with assistance possible, including a boot in their ass if they have yet to initiate an investigation. I also informed Circuit Justice Kagan by mail of the ongoing rebellion, which can be tracked using USPS tracking number, long one, within which I demanded she apply the Militia Act of 1792. This order is still sitting in the post office waiting pickup, even after my emailing her directly to have it retrieved. Please boot her ass down to customer pickup for zip code 20543 for her retrieval of said order. This is a national emergency. They shall not know the hour of his coming, but may Lord Almighty bring it, let it be soon. Amen to that. Amen. April 9th, 2016. Robert Allen Verlusky, Office of Christ. In the name of the Father, and Son, Holy Ghost. Amen. So, if you were to go look at things like the Emancipation Proclamation and the Second Confiscation Act, you would see that as long as every state has members seated in the Congress on January 1st of every year, they are to be considered not in rebellion with the United States. So all we need to do is go and see, well, do they have a certificate of election from their state? Did they file and subscribe an oath of office the way it says to do? Did they give their paperwork to the president of the Senate like they're supposed to do? Just a few simple steps. The very first one starting with, well, when they ran for office, they had to put in a certificate of candidacy or an affidavit of candidacy. No, affidavit of identity as part of their paperwork for candidacy. They said what name is their name and what name they're using, and see if it's the same. If not, well, it was an omission of a material fact, and the rest is a lie, and they're really not holding office. But they don't have a certificate. You know, none of these people have a certificate from anybody, and they're all using a middle initial because they're just de facto agents. And since it's de facto, it's all color of law and simulated legal process. And by God, that is a violation of the Constitution. Because Article 6 says, I'm going to go get that real quick. Hang on just a second. That's worthy of finding. Give me a second. Okay, so the Constitution of the United States, 1787. Let's just read the preamble. We the people of the United States. Right? It just says United States. We the people of the United States. In order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do obtain, ordain, and establish this Constitution of the United States of America. The isn't capitalized. Here they said United States of America. Here they said United States. They're not the same thing. Right? The people of the United States are writing a constitution for the people of the United States of America. People of the United States, this should actually be, the people of the United States, it should actually be the free and independent states, the United States of America, because the United States is a contraction of the United States of America. But United States of America is King George's jurisdiction, sharing the same ground. Right? This is, I don't know how they did her. Well, they did it so they can do what they're doing, right? We got two forms of government or two completely different systems running parallel to each other, and we've been blindsided, and instead of being in the Republic, in the United States of America, we're bond servants in King George's jurisdiction, United States of America. They'd like you to stay there. How do they do that? Well, they make sure that your proper identity is not known in the United States of America, or the United States of America would send the military in and, come to your aid and protection. So it goes on to say in Article 1, all legislative powers herein granted shall be vested in a Congress of the United States that shall consist, shall, of a Senate and a House of Representatives. They have to be there. Right? So the people actually have to be holding them offices for them to be there. The House of Representatives shall be composed of members chosen every second year. Well, we know that. And by people of the several states. And the electors in each state shall have the qualifications requisite for electors. Now, how come the electors, now these must be presidential electors, are included as members of the House of Representatives? Because the electors aren't congressmen that we would think of them as. They're these other group of people called the electors, made up of delegates. Right? So which one of those is actually the House of Representatives? Who is it they're speaking of? The U.S. representatives that we all believe we have, or the electors are the House of Representatives? I don't know. We're going to find out. And this is the big one, though. Section 3. The Senate of the United States shall be composed of 2 senators from each state chosen by the legislature thereof for 6 years. Now, the Senate of the United States shall be composed of 2 senators from each state chosen by the legislature thereof for 6 years, and each senator shall have 1 vote. Well, the legislature isn't picking the senators. Now, of course, this may have changed because this is the 1780 whatever. I don't know. That changed because now it's done by popular vote. The people vote for the senators, and I believe that would have been an amendment to the Constitution to do that. But regardless, are they actually sitting? What does a representative need to do to say he's sitting in office? And what does a senator need to do to say he's sitting in office? Well, we can find that out because that would be in your election laws, or it would be in 2 USC, United States Code, which is for the Congress. It shall be the duty, so this is 2 U.S. Code, subsection 1A, right, the very first one. It shall be the duty of the executive of the state for which any senator has been chosen to certify his election under the seal of the state to the President of the Senate of the United States. Well, we don't need to go any further. Call the governor and say, I want to see facsimiles of what you provided to the President of the Senate of the United States. The certificate mentioned shall be countersigned by the Secretary of State. So not just the Senate, not just the governor or the executive, but the Secretary of State have to sign with the Great Seal a certificate that's going to go to the President of the Senate of the United States to prove that the dude standing there has been elected to office. So if these certificates aren't in the drawer of the clerk, well, then there's nobody sitting in Congress, and you just violated the Constitution. I forget what one it was, but I will go look. Section 3, Article 1, Section 3 of the Constitution, in which it says the Senate of the United States shall be comprised of 2 senators from each state. Where are they? The oath of office shall be administered by the President of the Senate and each senator who shall be elected previously to taking his seat. Now they got to take an oath. Now, it doesn't say here, but they have to subscribe their oath also. Right? You can't just take it, you got to sign it. When the President of the Senate has, that's not taken, okay. Presiding officer, Senate may administer, Secretary. You can go read these yourself. They're easy enough to find, right? They're easy enough to find. It's all in 2 U.S. Code within the first 26 subsections, pretty much. Give enough because they're not going to be able to go any further, right? You can't check that off to say it was done. Well, we don't need to go any further. They haven't done this. So at the first session of Congress, after every general election of representatives, the oath of office shall be administered by any member of the House of Representatives to the Speaker, and by the Speaker to the members and delegates present and to the clerk, previous to entering any other business, and to the members and delegates who afterward appear previous to their taking their seats. The very, 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 very first thing they have to do at the very, very, very first session of Congress is this. Until they do this, nothing else has happened. The clerk of the House of Representatives of the 80th and each succeeding Congress shall cause the oath of office to be printed, furnishing 2 copies to each member and delegate who has taken the oath of office in accordance with law, which shall be subscribed in person by the member or delegate, who shall thereupon deliver them to the clerk, one to be filed in the records of the House of Representatives, and the other to be recorded in the Journal of the House and in the Congressional Record, and such signed copy, certified copies thereof, or of either of such records thereof shall be admissible as evidence in any court in the United States, and shall be held conclusive proof of the fact that the signer duly took the oath of office in accordance with law. Just go ask them for their certificate, please. I want a certified copy. Right? This all should be recorded in the Journal of the House and in the Congressional Record for the very first day of office of that particular Congress. They can't do anything else until they've done this. Before the meeting of each Congress, the clerk of the next preceding House of Representatives shall make a roll of representative elects and place thereupon the names of those persons and such persons only whose credentials show that they were regularly elected in accordance with the laws of their states respectively, or the laws of the United States. So this is prior to the first day of Congress, of the new Congress. Within the congressional record should be a roll that says all of these people were, because they're going to get elected in November, and we're talking January, so within that 6-week period there or whatever. Before the first meeting of each Congress, the clerk of the next preceding House of Representatives shall make a roll of representatives elect, and place thereon the names of those persons and such other persons only whose credentials show they were regularly elected in accordance with laws of their state respectively. Now let's think about this. How are they going to do this? Because before the first meeting of each Congress, the clerk of the next preceding House of Representatives shall make a roll of the representatives elect. But they haven't elected a clerk yet, which is what they do on the first day. They got to elect a frickin' clerk. So there is no clerk for the next preceding Congress. They haven't been elected yet. Now I could be misinterpreting that completely, but hey, that's what I'm going to go with until they can prove different. That's what I say it is. And this is the oath of office they're all going to take. I, A.B., do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I will take this obligation freely without any mental reservation or purpose of evasion, that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. Now they need to subscribe that, 2 copies. Now this is the House, and give it to the clerk who's supposed to put them in the records. Well, on the very first day, of the session. So it's very easy for somebody to go and investigate this that has the authority to do so. But if they don't want to tell me, it's kind of hard for me to do it. So I'm going to leave it at that. That was the whole idea, just to say, well, I just told I didn't like Clarence's answer, and so I had my own. But the great thing was, by going through this little gyration in the first place, hey, I got a real frickin' tracking number for a complaint that's supposed to be in some court. And, well, now that I have one, I'm going to appeal their decision and have it sent to the federal circuit. If this isn't an Article 3 court. Well, and all the other things I said. So we'll see what Clarence does. But I emailed it out, so hey, they'll have it tomorrow, and see what happens. Okay, everybody have a great day. See ya.